don't know why the reference to subject matter jurisdiction in the opening statement. Pretty.
Look at it. It's like, I don't understand why you brought that up. I mean, who's talking about that? Hey y'all, it's your girl J9 Eve, and as you can see on the screen, we have this handsome gentleman. He is eligible bachelor inside of the prison. Now, today we are gonna make fun of Darrell for Darrell-ish reasons. So the judge is trying to be, he's trying to get ahead of this Darrell-ness for the day, okay? And of course, Darrell's acting like, what? Huh? Which is the look he has on his face right now. This is what the look is like. What? I didn't say nothing like that. Even though I say it every 5 minutes. But let's see. Let's see what Mama's talking about. You gonna see.
All of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. I do not consent to being called that name for the record.
Yes, gotcha.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask.
Yeah, somebody else's street clothes.
As well.
And don't consent to being called that name.
I understand, sir.
I understand.
All right, I do want to put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about a page and a half.
Here we go.
I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not.
Now this is the thing that I was talking about. She's being preemptive, you see. In your opening statement, don't bother bringing up that subject, that matter, or that jurisdiction. I don't want to hear about none of them, okay? This ain't their court day. It's yours, okay? Don't be bringing up them three. I don't want to talk to them, okay?
Not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments.
Yeah, none of that. None of that.
With that, I believe
For the record, is this the which you're referring to? This
the page and a half is from my judicial bench book. I thought it would be helpful to you as so that you have a better.
Darrell, don't play dumb so hard. Honestly, it's when it comes natural to you, you shouldn't have to do this. Okay, just be you, honey. Just be you, and it will be dumb. Okay.
Awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
okay? I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. Pretty.
Look at it. It's like, I don't understand why you brought that up. I mean, who's talking about that? What? Ugh. I mean, I'm just saying.
Aware that
I'm aware.
wouldn't be part of an opening or closing statement.
Okay, great.
I don't get why that.
Okay.
I wanted to make the
relevant.
record clear.
Okay. And now she said that
So I
was great.
appreciate you indicating to me that you're aware of that.
Okay.
Even though subject matter jurisdiction has not been proven on the record, and should
Sir,
be
it does
addressed.
not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet to be
I'm not going to go
proven
down
on the
this
record.
path today. I'm just advising you, you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction.
That's hilarious, Daryl. That's hilarious. Oh, you already had common sense to know? Oh. I hadn't seen it, so I didn't know it was there. Where is it? Tell it to show itself so we can see it, because we ain't seen it yet. This could be something in your imagination for all we know, because we definitely have not witnessed this common sense you say that you possess, okay? At least I ain't seen it, okay? I'll speak for the world. We ain't seen it, okay?
Jurisdiction has not been proven for the record.
Oh, no? Oh, damn.
All right, next topic. Then I believe the state has
Should be
filed
proven
a
for the
motion.
record by the prosecution.
The objection is noted.
Yeah, we served him. What he done with it, we don't know.
All right, go ahead. You can make.
I didn't look at the document.
Oh, really?
I set for value, return for value the document. I didn't look at it.
Oh, no? Okay. Okay.
So
That's like, well, I didn't look at it, so, we can't proceed. Oh, they gave me a paper? Oh, yeah, but I ain't looked at it yet. And then just do the long pause, like you waiting for her to be like, okay, well, then let's shut this down so that he can go back to his cot and he can read this thing. And if it takes 1,000 years, then it takes 1,000 years. Nice try, Daryl. Nice try.
I don't know what I'm supposed to say to that.
All right, well, Attorney Opera, it's your motion. I'll hear from you.
Oh my God, he's
Your
so
Honor,
weird.
we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76.
Now this some petty Daryl shit. Watch this. Watch Daryl be super fucking petty. They changed one fucking word. One word. It was changed from at to near. Or from near to at. Okay. This is the word changing they wanted to do. And let's hear what Daryl's response is going to be. So Daryl-esque.
Information reads as it reads right now. It reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
Now here, let's
Thank
hear
you.
Daryl.
Any position on that, sir?
Yes.
Of course you do, Daryl. Of course you do. Now watch Daryl in all his pettiness. Oh my God. Oh my God. And the objection also, he says he don't see the difference that it would make, which means why the fuck do you care? Like, what? Just watch.
First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge.
Exactly. So then why do you care? So then it should
Understand
be able to
why
be changed.
emotion needs to be heard.
Daryl, if we gotta sit and wait for you to figure out how to understand something, I mean, whatever it is you're doing with your eye here, do whatever you gotta do. If you could produce a functional thought by doing it, then do it. Just make the crazy face if that's what it's gonna help with, okay? I'm doubting that it's gonna help with it. I'm doubting it, but you know, I've been wrong before.
About one word is I think kind of at this point kind of a moot point.
Is it moot? Is it moot, Daryl? Oh my God, Daryl, spell it. Hey, look. That's so crazy. You say, well, I don't see what difference it makes. It doesn't seem like it changes anything one way or the other. That means that you're okay with it being changed. Because you don't care, you don't think that it makes a difference, then you don't care. So they want to change it. Even like, well, I don't see that it makes any difference, and go for it, whatever. But instead is, I don't think they need to change it because I don't think that it makes a difference if it gets changed. What? Wait, what?
It's been charged like this for a year, basically.
Since you ran over a foot. Yes.
Ever been reference to being changed before yesterday. So what is the significance of this now at this point?
There.
Thank you, sir.
Shut up.
Court is guided by Section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. The charges are read. Those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So
What's up, Daryl?
This same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
Well, what happens if that happens?
I'm not going to answer that, sir. Can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do
Daryl
that.
can't
Actually.
hear good. Daryl can't hear good, Judge. Bear with
Okay,
me.
so we dealt with that
Makes
then.
no sense.
Yeah,
The
like
state
you.
has not rested yet.
Ain't that a funny thing for a Daryl to say? It makes no sense. Oh, you noticed, Daryl. You noticed. Did you look in the mirror? Oh, no? Oh, I thought that's what you were talking about. I thought you were talking about you. Because you definitely make no sense, Daryl. You make no sense, okay? You and your hairline, completely ununderstandable. Me no understanding you, okay? And me a don't know wanna to. Bars. If Daryl don't know how to do anything else, Daryl definitely knows how to slay me, okay? You slay me, boo. You always do. 'Cause that is you. Boo hoo hoo hoo. Y'all know what to do. Okay? Y'all behave. Behave. 'Cause I'm not gonna. No. No. But mama love you though. Yes, she do. Indeed she do. You know she do. Peace.